Hello and welcome to the fifth module of our training tool on strategic litigation designed for professionals working with destitute EU migrants. This is a series of 6 training modules on strategic litigation in EU free movement cases, which is designed for professionals working to promote and protect the rights of destitute mobile EU citizens. In this fifth module, we will examine how to make a complaint to the European Commission. You may find it useful to pause and watch this short video on how the European Commission works. A link is provided below this video. As a matter of EU law, Member States have to implement EU law. This includes the obligation to apply EU law with the same vigour as they would apply national law. The national authorities are under an obligation to apply EU legislation in an effective way and refrain from doing anything which might undermine its objectives. Under the EU treaties, it is the European Commission which is tasked with monitoring and enforcing EU law. In this role, the European Commission acts as a so-called guardian of the treaties. In this role, the European Commission cannot hand down judgments or force the competent authorities of Member States to abide by EU law. Instead, when the European Commission considers that a Member State has failed to fulfill its obligations under EU law, it has the power to launch an investigation and, if considered expedient, sue that Member State before the European Court of Justice. The Court will then decide whether that Member State has infringed EU law and issue a judgment accordingly. As a matter of EU law, any individual or organisation faced with any national practice, measure or law which they consider to be contrary to EU law can bring a complaint to the European Commission. The complaint may be brought in any of the official EU languages. A complaint must be submitted via the standard online complaint form, a link to which you will find below this video. The standard form for complaints asks for various details about the complaint. This includes details about the complainant, details of the authority against which the complaint is directed, the national measure suspected of infringing EU law, details of the instruments of EU law which have been breached, as well as a description of the nature of the problem. Once the form has been submitted, the Commission will send an official acknowledgement within 15 days of receipt of the complaint. It then usually takes several months to obtain a substantive written response from the relevant department of the European Commission to indicate what action they propose to take. There are several possibilities for how the Commission handles a complaint. The Commission may decide to investigate the matter further. They may write to the Member State concerned to set out their concerns and ask for an official reaction. In some cases, this is enough to prompt a Member State to take action to remedy the breach of EU law. The national authorities will then respond, setting out their proposed remedial action. However, if the Member State does not respond, or their response is considered lacking, or does not adequately address the problem, the Commission may decide to issue a letter of formal notice. This is a first necessary administrative step in the opening of formal infringement action under the EU treaties. This can take several months to happen from the time the complaint is filed. Alternatively, the Commission may decide that there is insufficient evidence that a breach of EU law has been committed. In that case, they will write back to the complainant and indicate they are going to close the file. The complainant then usually has 30 days to make additional representations as to why the complaint should not be closed. We can return to the GMA case previously discussed in Module 3 on judicial redress to consider further how a complaint before the European Commission works in practice. As you will recall, in December 2020, following strategic litigation undertaken by the EU Rights Clinic with FEANTSA's support, the European Court of Justice issued a ruling which found that Belgian legislation on the registration of EU job seekers was contrary to EU law. The court considered that Belgian law did not comply with EU law because it imposed a requirement on EU job seekers to prove they have a genuine chance of being employed at the time of their first registration. Instead, the court ruled that the Belgian authorities should first allow EU job seekers a reasonable period of time to find work before obliging them to provide evidence that they have a genuine chance of being hired. Because this concept is interpreted restrictively by the Belgian Immigration Office, this is often used as a reason to refuse registration to any EU citizen who is looking for work, but who is unable to present a job offer within a few months of arriving in Belgium. Despite the European Court of Justice having found that Belgian law did not comply with the EU free movement rules, the Belgian authorities have been dragging their feet in amending their law. As a result of this persistent state of non-compliance, the EU Rights Clinic and FEANTSA filed a joint complaint against Belgium before the European Commission in October 2021. The text of the complaint contained a detailed explanation of the Belgian rules concerned and how they were contrary to the ruling of the Court of Justice in the GMA case. The complaint also contained a number of recommendations on how the rules should be amended in order to comply with the judgment. The complaint concluded with a call for action by the European Commission to open formal infringement proceedings against Belgium. Upon filing of the complaint, the Commission duly acknowledged receipt and then wrote to the Belgian authorities to ask for an explanation. Given that the response of the Belgian authorities was not deemed satisfactory, in July of 2022, the European Commission proceeded to issue a formal letter of notice against Belgium. In its letter, the Commission called upon Belgium to grant first-time EU job seekers the right to reside in the country for a reasonable period of time when looking for work. In the event that Belgium fails to amend its law, the Commission may decide to send a reasoned opinion, which is the last required step before being able to take the matter back to the European Court of Justice. We now await the response of the Belgian authorities. There are several objectives of lodging a complaint before the European Commission. One objective of making a complaint is to publicize the existence of the problem. Although the complaint will not be made public, there is nothing to stop a complaining organization from putting out a press release or putting up a post on its website as a way of naming and shaming the member state concerned. Another objective of making a complaint is to encourage the European Commission to launch an official investigation into the actions of a member state. This is usually begun by the European Commission sending out a letter to the member state to set out their concerns and request an official response from the member state concerned. The aim here is to incite member states to remedy breaches of EU law without going to court. However, if the member state does not provide a satisfactory response or fails to respond, a complaint also has the purpose of encouraging the European Commission to launch formal infringement proceedings against recalcitrant member states. The ultimate aim here is to persuade the European Commission to bring the matter before the European Court of Justice to obtain a judgment that confirms that the member state concerned has breached EU law. However, it should be noted that the European Commission has no power to impose any fines. Only the court can do this in certain cases. Also, the European Commission has no mandate to order reparation in such cases. Reparation can only be ordered by the national courts of the country concerned. You will find other useful links related to bringing complaints to the European Commission below. This concludes our fifth module, which provided an overview on how a complaint can be made to the European Commission against a member state that breaches EU law. We hope that you found it useful.